student loan plan.
Yeah, breaking news this morning. The Supreme Court is ruling against President Biden putting an end to his plan to forgive roughly $400 billion worth of student loan debt. We've been talking to constitutional law attorney David Coale. Welcome this morning.
Thank you.
You just finished reading these, just in the commercial break there.
Literally hot off the presses. But,
right.
That shows how all of America is doing the exact same thing. It has an interest in these cases. And there were two of these. They came from different places, one from here in Texas, another from another jurisdiction. And one of the cases, the court dismissed the action on standing, an interesting procedural issue, but really of interest only to lawyers. On the merits, they said it's just too far. The statute lets you make certain things. This is not one of those things. Sorry, you didn't have the statutory basis to do this.
Yeah, and the president said he was utilizing this HEROES Act that gave the Secretary of Education the power to protect borrowers, basically. Yes. And people remember this happened during the pandemic. The liberal justices, though, said that equals a green light from Congress.
Yes, and so that's what the majority opinion is about in the case that actually reaches the merits, is what is authorized by the HEROES Act. And there's this one line in there in an opinion that's otherwise pretty technical, where it says this is a modification of the loan program, the same way the French Revolution was a modification of the French nobility. The point being, it allows you to do certain things, and okay, yeah, maybe you can sort of force that into those words, but it doesn't fit as a matter of natural reading of words. And you just went too far here, Mr. Biden.
Yeah, well, and this was a tricky one too, because you've got a lot of people, even supporters of the president, who didn't like that idea. And then the other half says, oh, that's great. And of course, those probably are the people who had the loans or are paying off those loans.
There's enormous personal interest here for good reason. This is a very significant issue in the country. But the power issue is a huge one, too. We saw this in the last administration. We see it in this one. Presidents don't have magic wands. And you can't go around forgiving things just because you think it's a good idea. And this opinion is a reminder of that, that Congress sets rules for this sort of thing, and you can't go beyond that. And by the way, courts have rules too, is what the other opinion tells us. You can't just waltz in and sue anytime you want to. So these two opinions together, never mind the importance of the policy issue, which is very important, are very important rule-setting cases for how our three branches of government fit together.
Well, and you mentioned an interesting point there, because I think a lot of people were saying, is this going to set a precedent for states who don't like a ruling from the White House just to go and sue anytime they want?
Sure, and the answer that we have here is you have to dot your I's and cross your T's. We've had a couple of those cases this term. This adds to that body of law. Clearly, the Supreme Court feels like it has enough to do without every idea from a state being brought before it, and so they're going to have to be more cautious.
All right, let's talk about the other ruling this morning. The Supreme Court ruling in favor of a Colorado graphic designer who refused to create a website for a same-sex couple. This one sounds very familiar.
Yes, no, there's any number of things. Colorado has a very broad state civil rights statute. And so that has led to a lot of litigation. And a lot of constitutional cases sometimes turn on what label you put on the activity. And this is one of those cases. If you call what the web designer doing is doing conduct, certain consequences come from that. You can call it speech, other consequences. Here, a majority calls it speech and says we have a long tradition in this country of not forcing people to talk in a certain way. This case falls within that category of cases.
Legally, did it matter when she says, or both of them actually, and we're talking about that other case years before that, 2018, I think, with the cake designer, where they said we're artists.
Yes, there's some of these distinctions get pretty metaphysical, and there's obviously some back and forth between the majority and dissent, as there was yesterday in the affirmative action case about, wait a minute, are we reading the same law books? But we have what we have today, and we have a definition that this particular activity is speech-like enough to come within the line of cases, the strong line of cases, that say you can't make somebody say something. Now, where it's going to go from there to other laws and other protected classes, well, we're going to see a lot of litigation about that, because that's a broad invitation.
Yeah, boy, these are some big cases yesterday. Affirmative action, you've got the case today about the same-sex couple ruling there on this. A lot of maybe legal implications down the road. People will be talking about these rulings for quite a while.
For sure. I mean, that's what makes the Supreme Court supreme. It takes these issues and sets some broad guidelines, and then it's up to everybody else in the country for the next 10, 15 years until they take the issue back again to develop it, flesh it out, see what actually comes of it. We don't know what's going to happen with affirmative action. Are colleges going to do certain things in response or not? What will the courts do? And that's going to be our challenge for the next several years there and with these civil rights cases as well.
Now, these these were the big ones that we'd been talking about or waiting on. What else does the Supreme Court have yet to decide on?
If they've got anything else, I don't know about it. It's going to be some obscure thing. But I think this covered it. I mean, it's the end of June. Their term ends. They want to go on vacation, too. So, you know, they've put in a good terms of work, and it's time for a little break.
I'll tell you what, we appreciate your analytical mind this morning.
Thank you very much. I appreciate it.
And legal expertise. All right.